The following is a special video presentation from the Las Vegas Review-Journal. You are watching RJ Debates 2020. Here is your host, Victor Jakes.
Hello, I'm Victor Jakes. Welcome to the Las Vegas Review-Journal's Nevada Judicial Debate Series. Today's debate is between the two candidates running in the general election for Clark County Court Department W. They are Stacy Rocheleau and Adriana Rincon-White, and this is actually a new seat, so there isn't an incumbent. We'll start by giving each candidate a 1-minute opening statement. Stacy, go ahead.
Thanks, Victor. My name is Stacy Rocheleau, and I'm running for, as Victor said, the new seat, Department W. And I have 19 years experience as an attorney. I'm a family law attorney right now for Wright Lawyers. I'm from Henderson. I grew up here and I attended local public schools. I've been married for 27 years and I have 3 teenage daughters. I think raising a family here, along with my experience, gives me a unique perspective when deciding family law cases.
Thank you very much, Stacy. Adriana?
Thank you to the Review-Journal for hosting tonight's debate. My name is Adriana Rincon-White. I have the honor of serving the residents of Clark County currently as a hearing master in Dependency Court. This is a court that is a specialty that handles the child abuse and neglect cases. I was appointed to this position in 2018 by the chief judge on the recommendation of the majority of judges. Prior to that, I served as a part-time hearing master in domestic violence and child support court, also as a truancy diversion judge. I have over 6 years of judicial experience. When I was in private practice, I represented over 3,000 clients in various areas of family law, but always in family law. That's my passion. I am married to Gary, who is a teacher at Clark High School and a member of the UNLV Athletic Hall of Fame. And together we're raising 2 children ages 7 and 4. Thank you.
Thank you very much, Adriana. Stacy, we'll start with you. Divorces and custody cases are a big part of family court. Imagine there was a 14-year-old who only wanted to live with her mom, although both parents were safe, stable, and seeking custody. How much weight would you give to the teenager's request?
So that's a great question, Victor. This happens all the time in family court, and in my experience, I've had this happen before. What we look at when we decide custody is we look at the best interest of a child. And one of the best interest factors is the wishes of the child. However, the wishes of the child is a voice, it's not a choice. So it's really not up to the child to decide. It's up to the judge to decide whether or not that child is going to live with one parent or the other, especially when both parents are, as you said, they're both equally matched. As a judge, I would have to examine all of the circumstances and make a decision which is in the best interest of that child. Thank you.
Thank you very much, Stacy. Adriana, what would you do in that case?
I agree with Stacy in the sense that a 14-year-old has a voice. However, a judge is not to rubber stamp the preference of that child. I would look at the totality of the circumstances to determine whether the reasons this child is more aligned with one of the parents over the other are in the best interest. I have to also consider the rights of both parents and weigh those. I would try to find out if there was a way to help the child mend whatever it is the issue that's holding her or him back from wanting to be both parents, and offer a solution in that regard. Also try to discover the motivations behind it and try to offer a solution to that problem. But you do have to weigh the totality of the circumstances in order to make that decision in line with the best interest of the.
Thank you, Adriana. And we'll start with you for this one, Adriana. As we've kind of hinted at here, divorce, custody, very emotional, very hotly contested. Why are you the best candidate to help the parties resolve those disputes as peacefully as possible?
Well, Victor, I work in a very highly emotionally charged courtroom right now. I usually meet parents on what is probably the worst day of their life, within 72 hours of their children being removed. So they come in there emotionally charged. The first thing I have to do is treat them and receive them with the dignity and respect that they deserve, so that they understand that this is not a hostile courtroom. I lay the groundwork and the ground rules and basically explain to them the process so that they understand. Also encourage them to be part of the solution and not the part of the problem in resolving whatever legal issue brings them before me. I am a problem solver by heart. I am very solution driven, and I have a calm demeanor, and I treat people with respect. And I think that helps in bringing these cases to a resolution in an amicable way.
Thank you very much, Adriana. Stacy, same question for you. Why are you the best candidate to help people in very emotionally charged situations resolve their disputes as peacefully as possible?
So in family law, these are very good people on their very worst days. It is a very highly emotionally charged area of law. They're anxious, they've got some angst going on. And in my experience, I've represented over 5,000 clients over my years, and I've been able to bring them to a peaceful resolution through settlement conferences, through alternative dispute resolution mechanisms, and keep them out of the courtroom. And I think that's one area that I can excel at if I'm appointed or if I'm elected judge.
Thank you, Stacy. Stacy, we'll start with you for this question. What's one deficiency you see in the family court system, and what would you do to fix it if elected?
So one deficiency I see in the family law system are judges that refuse to award attorney's fees for frivolous motions. And I'm talking about motions that are filed by attorneys who should know better. And in our system right now, we have a lot of judges that are refusing to award attorney's fees. And these frivolous motions, they clog up the system, they clog up the docket, and they delay justice for those that need justice. And so if I were elected to the bench, I would implement and awarding attorney's fees for those frivolous motions.
Thank you very much, Stacy. Adriana, what about you? What's something you would want to change if you are elected?
One of the deficiencies that I see is the lack of decisiveness. It is our responsibility to help people resolve their legal issues. And I believe that those decisions need to be delivered in a timely fashion. I see a lot of hearings being continued, being delayed, status checked, taken under advice because people just can't make a decision. So I work very hard to prepare myself to ask the important questions that are needed in order to arrive at a decision so that I could render a decision from the bench at the conclusion of every hearing if possible.
Thank you very much, Adriana. And stick with us. Our judicial debate will continue in just a moment.
All your listeners and followers, the best name of any podcast in the world is podcast.
Nobody's ever done it. Nobody's ever faked
Not that we know
their
of.
death. No.
When you work with Prince, you got to get used to the fact that he changes musicians like underwear. You know, like
Tom Brady. And Tom Brady, he's a quarterback in the Boston area.
I'm not sure who you're talking about.
Get ready for every Raiders game with us. Vegas Nation Game Day will give you everything you need to know about each week's matchup.
I'm excited.
Sundays at 9 a.m. starting in September on Your View. Vegas Nation Game Day coming this September.
You're watching the general election debate for Family Court Department W. It's part of an ongoing series of debates produced by the Las Vegas Review-Journal to inform local voters about these important races. Adriana, you've only been a lawyer for a little over a decade. Why should voters put someone on the bench as a judge who has such little experience practicing law?
That's a great question. I'm glad I have an opportunity to explain. I have been licensed in the state since 2008, but my first judicial appointment came in 2014. Out of 12 years that I have been licensed as an attorney here, half of that time has been spent on the bench actually doing judicial work. I have been appointed to these positions by other judges, by colleagues of mine have recommended me for these appointments. During the time that I was an attorney, although the years that I practice are not as great as Ms. Rocheleau's, I represented thousands of clients. I was in court practically every day. I attended settlement conferences and trials. So I don't necessarily think that the experience of someone should be judged by how many years they have on their law license, but however the experience that they possess. And I take pride in the fact that since a very young age in my career, I was given the appointments that I have received thus far.
Thank you, Adriana. Stacy, on your business website, it says that you are, quote, never one to mince words, end quote. Shouldn't a judge be a person who exercises discretion over what they say from the bench?
I think that the judge should exercise discretion over what they say from the bench. However, in private practice, you have to be very honest and very truthful with your clients. When I say I don't like to mince words, I like to tell my clients what they can expect when we go to court, if we have to go to court. And I think that's very important for a client to know. That attorney-client relationship is so vital. And if the attorney isn't truthful with the client, or the client cannot rely on what the attorney's saying, then the entire case falls apart. So when I say I'm not one to mince words, that's more what I'm talking about there.
Thank you, Stacy. Stacy, what characteristic or experience do you have that most distinguishes you from Adriana?
Well, Victor, I would say my 19 years of experience as an attorney most distinguishes me from Adriana. I've got almost 2 decades, and like you mentioned, she has little over 10 years experience, which is the minimum to run for a judge. And so I think with my experience, I'm fair-minded, I'm patient, and I'm very hardworking. I've built up my firm, Wright Lawyers, from 2003 with just myself to where now we are a successful law firm of over 4 attorneys. And so I think with my hardworking and my experience, that sets me apart.
Thank you very much, Stacy. Adriana, same question for you. What characteristic or experience do you have that most separates you from Stacy?
Well, I would have to say that the obvious one is that I have insight as to how to run a courtroom. I have done judicial work for over 6 years. I have handled small preliminary hearings all the way to trials, where I have had to decide whether to terminate someone's parental rights. That's a heavy burden. I know how it is to hear witness testimony, process evidence from the judicial perspective. I know how to run a stacked calendar and keep cases moving effectively. So again, that has been something that I have earned through my hard work, my diligence, and being recognized by other judges that I am an outstanding member of the bench who can carry out the roles that I've been appointed to.
Thank you, Adriana. Adriana, is it more important for a judge or a hearing master in your case to enter the courtroom ready to make a decision, which speeds things along, or should they be open to persuasion during oral arguments, which can cause a delay in issuing a judgment?
That's a great question. I think that every judge needs to prepare for every hearing and keep open mind. Especially in family court, Stacy will know this, we deal a lot with pro se litigants who sometimes leave things out of pleadings simply because they lack the knowledge and experience. So while a judge needs to be prepared with which way they're going, in which direction they're going in a case, they need to keep an open mind. They need to be active listeners and ask questions in order to make sure they reach the correct decision. So I think it's a balance of those things. I think you need to be prepared to make a decision, but you also need to be open for additional things that come up.
Thank you, Adriana. Stacy, same question for you. If you are elected, will you come to the courtroom ready to make a decision based on the pleadings, or will you be open to persuasion during oral arguments?
Victor, I also agree with Adriana. I think the judge needs to come into the courtroom absolutely prepared. In family court, we have hearing videos that we can watch of the prior hearings. There's pleadings that we can read. The judge should be 100% up on the case before they walk into the courtroom. However, in family law, it's often a fluid situation. It's moving. There could be a DUI that happened the night before the hearing that didn't hit the pleadings. So the judge needs to take oral argument and to take new facts into consideration that have happened since the pleadings were filed. So I do think it's a balance. I think that the judge needs to ultimately be prepared, but should be willing to take oral argument and listen to the arguments of the parties.
Thank you, Stacy. And stay tuned. The debate will continue right after these messages.
With so much excitement building around the Raiders and their inaugural season in Las Vegas, the fans want to be heard. The launch of Vegas Nation Fan Zone is their answer. That's right, Raiders fans can sound off on all things Raiders, from players to coaches to even the new Allegiant Stadium. Vegas Nation Fan Zone is accessible 24/7 and allows fans to generate and upload their own posts for lively interaction. Simply go to fanzone.vegasnation.com to sign up today.
Welcome back, and thank you for joining us. You are watching the judicial debate for Department W. Stacy, we'll start with you. As we've talked about, Clark County is going to have 3 new judges working on child abuse and neglect cases, which is the foster care system. Acknowledging, obviously, that every case is different, how much time would you give a birth parent who took only inconsistent and sporadic steps to work their case plan and attend visitation before terminating their parental rights?
Well, Victor, in Nevada, we have statutes, and we also have federal law that govern how long we're supposed to give a parent to work a case plan. And so I would be bound as the judge to follow those statutes and case law. My understanding is that we have a 6-month benchmark that we look at, and then we have a 12-month benchmark, and the child is really entitled to permanency within 12 months. My understanding is we can go up to 15 months. However, the child should get some type of permanency within 12 months. We also have due process considerations, and then we have the constitutional rights of the parents to parent. So there's a lot. These are complicated cases, and there's a lot that we need to take into effect before we just terminate parental rights.
Thank you, Stacy. Adriana, you work with these cases on a daily basis. Will you talk us through your thought process on what goes into how long you would give a parent who's not making any effort?
Well, Stacy is correct in saying that there are statutes, there's case law, and there's federal guidelines that lead us to that. But at the 6-month mark, you get a good idea of how the parents are doing, whether they're engaged in services or not. I usually give them a kind of a talk of what it's looking like if they continue to engage, what it's not looking like if they're not engaging, and I try to motivate them to do so. At the 1-year mark, which is the permanency hearing, you do have to kind of balance more the rights of the child at this point. And if parents show up and haven't really been engaged in services, I really don't have the choice but to establish permanency as TPR adoption without compelling reasons. In order to keep reunification as a goal, you have to have a fact-finding statement of compelling reasons why you should give somebody more time. And usually compelling reasons consist of things such as reunification being imminent, not just barely engaging in services. So there's a big process and weighing of factors that go into this.
Thank you, Adriana. Adriana, this question is going to be for you, but I'm going to give some background before I get to it. Recently, you may have seen it, the Review Journal did an investigation on the tragic case of Aaron Jones, who died at 13 and who CPS workers had been in contact with multiple times throughout his short life. His father and stepmother were indicted for his murder. Months before he died, then hearing master David Gibson gave custody of Aaron to his father despite a previous criminal conviction for child abuse and neglect. Gibson said in the article, quote, "The court's hands were tied based on the law, even as I had personal reservations," end quote. So Adriana, this is my question. If the law required you to place a child with a biological parent that you personally believe represents a threat to that child's safety, would you follow the law or protect the child?
Well, I have to say that I took over for Judge Gibson's docket, so that's actually a case on my docket, and I cannot personally comment on that case.
Oh.
However, to answer the question generally, I have to put the safety of the child first. And in order to justify otherwise, I have to make findings of fact. So if a situation like that would arise, I would likely set an evidentiary hearing so that I can hear evidence and I can put it in writing as to why I'm making the decision that I'm making. As long as a judicial officer can articulate the reasons why they're making the decision and pair them up with the law, it's going to be very difficult for someone to overturn that decision. So that's how I would handle that situation.
Thank you, Adriana. Stacy, same question for you. If you feel that the law requires the child to go back with a parent that you don't think is safe, what would you do?
Well, what I would do, Victor, is I would balance the rights of the child along with the rights of the parents. And I would look at the totality of their circumstances, and I would look at the best interests of the child. I would also look at the safety of the child going back to the parent. And there is a certain amount of judicial discretion that judges have. And so in exercising that discretion, Adriana's correct, they do need to make findings of fact and conclusions of law so that that wouldn't be overturned on appeal. But you certainly could exercise your judicial discretion, excuse me, in order to place the child with whichever parent they would be safe with.
Thank you very much, Stacy. And we'll be right back with our final segment in just a moment.
The Vegas Nation podcast is your source for all your Las Vegas Raiders news. Subscribe and get fast takes and smart coverage. Download the Vegas Nation app, check out vegasnation.com, and stay up to date with your Las Vegas Raiders.
Alexa, play my flash briefing.
Here's what's new in today's news.
Stay in the loop of the latest information in the Las Vegas Valley with the Las Vegas Review Journal flash briefing. Every day, we will provide you with everything you need to know in news, business, weather, entertainment, and sports. Go to the Alexa app and search LVRJ News Briefing. Then say, Alexa, play my flash briefing to hear 3 minutes of the most important information in Las Vegas.
Welcome back to our judicial debates. Stacy, this question is for you. If you are elected to the bench, what do you want your legacy to be? And I've only got about 45 seconds.
Sure. If I am elected to the bench, I would like my legacy to be that I was fair-minded, patient, and hardworking. I think that those are three very important traits that a judicial officer can bring to the bench, and that is what I would like to leave as my legacy.
Thank you, Stacy. Adriana, same question for you. Again, 45 seconds. If you are elected, what do you want your legacy to be?
When I'm elected and after the end of my judicial career, I would like to be remembered as the judge who cared on the bench and off the bench. I believe that community is very important part of the judicial system. We need to support our youth. We need to support our families. And I greatly believe in that. I am involved right now a lot in foster youth because that's what I work in. And so caring really enhances your experience in the courtroom as a litigant and your experience and impact that you have on the community.
Thank you very much, Adriana. And it's time for our closing statements. We'll give each candidate 1 minute. Adriana, go ahead.
I'd like to thank the Review Journal once again for hosting this debate and Ms. Rocheleau for engaging in this conversation. I am the only candidate in this judicial race with judicial experience. I have been doing the job of a judge for some time now. I do not need on-the-job training. I have handled matters from the time of their preliminary stages all the way to trials. I have had to make decisions such as whether to terminate someone's parental rights. That has been a very important facet of my job. I sat through witness testimony, processed evidence, and weighed all the facts and evidence against the law of the state. I have demonstrated through my work that I am fair, compassionate, diligent, that I make decisions, and most importantly, that I treat everyone who appears before me with dignity and respect which they deserve. I have been endorsed by law enforcement and veterans, and I hope I can count on your support on November 3rd. Adriana Rincon-White for Family Court Judge, Department W. Thank you.
Thank you very much, Adriana. Stacy, 1 minute.
Thank you, Victor, and thank you to the Review Journal for hosting these debates. I want to also thank the viewers for watching. I think it's important for everyone to vet the candidates and to become knowledgeable before voting. My name is Stacy Rocheleau, and I'm running to be your District Court Judge in Department W. I have 19 years of experience. I have represented thousands upon thousands of clients in everything from divorce, custody, child support, alimony, adoption, relocation, anything that falls within the family law purview, I have represented a client with, and I am the best candidate to be your next judge in Department W. Thank you.
Thank you very much, Stacy, and thank you both for joining us, and thank you for watching this edition of Nevada Judicial Debates. Remember, you can find this program and more information on all the judicial races at reviewjournal.com. We'll see you next time.